Hello students, in our previous class we have started a discussion about essential elements of a valid offer. In our last class we have already discussed 6 points of essentials of a valid offer. Now in this class we are going to talk about 6th point, that is offer must be communicated. So in order that the offer should be complete, there must be communication of offer to whom? To the person to whom the offer is made. Unless and until the offer is communicated to the person for whom it is meant, there can be no acceptance. If there is no communication of offer, no acceptance, and it will not lead to any agreement between the parties. So an acceptance of an offer in ignorance of the offer is no acceptance and does not create any legal right on the acceptor. Acceptor means the person who accepts the offer. That means he is the offeree. Offeree means person to whom the offer is given and he is the acceptor. If an acceptance of an offer is made in ignorance of offer, the acceptor, the offeree does not know anything about the offer and he makes an acceptance. That is not a valid acceptance and it will not give any legal right to the person who has accepted the offer. Clear? So if there is no communication of offer, the person, acceptor or promisee or offeree cannot accept that offer. It is not a valid acceptance. It will not lead to an agreement between the parties. We have seen that. What is the offer plus acceptance? It leads to an agreement between the parties. Agreement plus enforceability by law is equal to, it will lead to a contract between the parties. Can it happen like this? Acceptance first and then offer. Will it lead to an agreement between the parties? No, it cannot happen. There will be no agreement. So first there should be offer, there should be communication of that offer to the offeree and then only acceptance should be there. It cannot happen in this way, opposite way, that is first acceptance then offer, and it will not lead to any agreement between the parties. We have a famous case law on this point, Lalman Shukla versus Gauri Dutt. Often a case study is asked on this point. Now what is this case? So this Lalman Shukla versus the Gauri Dutt, this case is decided in the year 1913. What are the facts of this case? There was one person, he was a master, M. Master sent his servant S. S is the servant, M is the master. So master sent his servant to trace missing nephew. Master's nephew was missing and master told his servant to search for his nephew. M. Master. In the meantime, so the servant went in search of the nephew and in the meantime, master announced a reward for providing information about missing boy. He declared that, he made an announcement that whoever gives any information about missing boy, I will give you such and such amount to that person by way of a reward. S. Servant. Servant does not know anything about the announcement. So servant, in ignorance of announcement of reward, traced the boy and informed master M. So servant does not know anything about the announcement of the reward. He found out the boy and informed his master M. Servant, after informing the master, afterwards servant came to know that there was a reward which was declared, which was announced by the master, and now he wants to claim that reward. So he filed a case. So he went and asked his master to give that reward to him. Master said that he will not give him reward. Now the servant filed a case against the master claiming that reward. He said that there was a reward which was announced by you for tracing your nephew and I have given you information about your nephew and I am eligible to get that reward. Now in your opinion, whether the servant is eligible to claim that reward or get that reward? So what we have seen that first there should be offer, then acceptance, then it will lead to an agreement between the parties. So here, whether there was an offer from the master in the beginning itself, The claim of the servant was dismissed by the court. Court said that the servant is not eligible to get the reward. Why? Because he was ignorant of the offer. So when he did something, when he found out the missing boy, he was not aware of the offer given by the master. He was not knowing that there was a reward which has been declared, which has been announced by the master. He was not knowing anything about that. Therefore, his claim was dismissed. So what he did, servant found out the nephew. What he did, it was his duty of the servant towards the master. So he was just obeying the orders of his master. When he found out the missing boy, he was unaware of the reward to be given, to be declared by the master. Therefore, he is not eligible to claim any reward. For example, A, without knowing that a reward has been offered for the arrest of a particular criminal, catches the criminal. A person catches a criminal, person is unaware that the government has declared or any reward for catching such a criminal. In this case, A cannot recover the reward as he cannot said to have accepted the offer. So, when he did that thing, when he caught the criminal, he was unaware of the reward. Therefore, what he did, he did not do it as per the offer which was given by another person. Therefore, so he is not eligible to claim the reward. On this point, often a case study is asked. Case study will be asked in this way. The dog of A was missing. So A's dog was missing. He distributed handbills whereby announced a reward of 1000 rupees. So A's dog was missing and he distributed handbills, and in that handbills he wrote that such and such he gave the description of the dog, such and such a dog is missing, and anybody who comes across such a dog and he brings that dog to me, he will be eligible. I will be giving 1000 rupees to that person by way of a reward. This was an announcement made by A. B is the person who knows A as well as he very well knows his dog also. So B had not seen the handbills and he traces the dog of A and he gets the dog to A. Afterwards, B came to know about the handbills which were distributed by A. Now, whether we can say that B had validly accepted the offer of A? No, B has not validly accepted the offer of A. Would the position be different if B had seen the handbills? Yes. If before finding out the dog or before tracing the dog, if B would have seen the handbills and then he would have found out the dog and given that dog to the master A, then he would have every right to claim the reward of 1000 rupees. But if when he has not seen the handbills, he does not have any right. So this is the point on which how the case study is often asked. 7th point is, offer must be made with the view to obtain the consent of the offeree. So when the offer is made, offer is effective only when it is communicated to the offeree. So the communication of offer is necessary. Until the offer is made known to the offeree, there can be no acceptance of an offer and there can be no contract. So offer, when a person makes an offer, that offer must be made with a view to obtain the consent of the offeree. If there is no such intention to get the to obtain the consent of the offeree, we cannot call it as a valid offer. Say for example, two friends they are talking to each other, casual talks, and one friend says that casually he says other friend that this is my new phone and if what is a big deal, I can give you this phone for 25 rupees. Then another friend to whom the other friend tells that, he says that yes, I am ready to purchase this phone for 25 rupees. Now give this phone to me for 25 rupees. In this case, it is not a valid offer, not a valid acceptance. Why? There is, whenever offer is given, there must be an offer must be given with a view to obtain the consent of the offeree. Here, there is no such view, therefore, no valid offer. Yes. Eighth point is offer may be conditional. So whenever offerer is giving an offer, he may put some condition for acceptance of the offer, and the acceptor or the offeree who accepts the offer, he must fulfill all the conditions which are attached by the offerer. An offerer may attach any terms and conditions to the offer he makes. Offeree will have to accept all the terms, and he has to accept all the terms of the offer. There is no contract unless all the terms of the offer are complied with, and acceptance is in the mode prescribed by the offerer. Say for example, offerer says that this is an offer. I want to sell my car to you for 2 lakh rupees, and to convey your acceptance, you have to write me a letter. So this is the condition which is put forth by the offerer, and while accepting the offer, offeree or acceptor has to write a letter to the offerer. If he himself personally goes to convey the acceptance, it is not a valid acceptance. So acceptance must be made in the mode which is prescribed by the offerer. So offerer can put forth any condition for the acceptance, and offeree or promiser or acceptor has to convey his acceptance in the mode which is prescribed by the offerer. Ninth point, no term, the non-compliance of which amounts to acceptance. So while giving an offer, the offerer cannot say that non-compliance of something will be acceptance. Now what does it mean by that? The offer should not contain the term of non-compliance would amount to acceptance. That means A has given an offer to B, and if the acceptance is not, he cannot say that if you will not convey, if you will not give your acceptance within 5 days, I will think that you have accepted my offer. No, this cannot happen. A man cannot say that if acceptance is not communicated by a certain time, the offer would be considered as accepted. So the offer should not contain the term of non-compliance. Means if you will not convey your acceptance within 5 days, I will think that you have accepted my offer. No, this cannot happen. So it would not amount to acceptance. So these are the 9 points of valid offer. So this is a question on which often a question is asked for 5 marks. What is offer? Define offer. What are the essentials of valid offer? Or usually asked question, that is a case study on Lalman Shukla versus Gauri Dutt. Thank you.